Welcome to Pig Pods. We give you actionable insight and stories behind real-life success wherever you go. Here are your hosts, Angelos and Mo.
Welcome to Pig Pods, your success podcast. I'm Angelos.
And I'm Mo.
Today we're interviewing Phil Oak, partner at GA Solicitors based in Plymouth, on how to regain possession of a property in the correct manner.
Philip, thank you for joining us.
It's great to be here, guys. Thanks very much.
So, Philip, let's get down to it. So, surely if somebody isn't paying rent in a property you own and you're letting it out, or they're damaging the house, you can just go around there and boot them out, right?
No, I'm afraid it doesn't work like that, guys.
Okay, so what would you say the most common reasons a landlord would want to regain possession of a property?
Well, there are a number, Angelos. The main two, I would say, in my experience, are landlords wishing to sell, and also situations where tenants, for whatever reason, have found themselves in arrears, usually 2 months or more. Sometimes you get a difficulty with a tenant in terms of behaviour. Other times it's totally non-fault based. You may have a landlord with a portfolio who decides, well, I want to change the use of this property, I want to do a refurb, I want to convert it, for which purpose I need a vacant property, so I need the tenants out. And just occasionally a landlord will want it for somebody else. I had a case a few years ago where I was instructed by a landlord to evict their tenant because they'd got a granddaughter who needed a place.
Okay, so there's many reasons.
Yeah.
Not just simply because the tenant isn't paying or the tenant causing damage. It could be that the person may want to sell their house. There's all sorts of reasons that you need to serve correct and proper notice in order to get your property back in your possession.
So, Phil, what documents must a landlord have before any notice is served?
Well, a number, Murat. First and foremost, I need to see a tenancy agreement. I need to see a written tenancy agreement. This will usually be an assured short-hold tenancy agreement because, as you guys know, and our listeners will probably know, that's the main kind of tenancy these days.
And do you see cases where there's actually people living in houses without any written agreement?
Well, in fact, I do. I've got one on just at the moment. It's not an insurmountable problem because ASTs, as they're known in the trade, assured shortholds, can be granted verbally, but as with most things in life, it helps to have something in writing. I'll still be able to evict this particular tenant, not least because the claim is based on rent arrears, but it just makes it a little bit more involved.
So we have the tenancy agreement.
Yeah.
What other documents do we need to make sure that we are forearmed with?
Well, next, if a deposit is taken, and most of the time a landlord will take a deposit, I need to see a copy of the prescribed information which the landlord is obliged to supply to the tenant, and also a copy of the deposit protection certificate. That's a document that will be issued by the relevant tenancy deposit scheme, and it's proof of registration and also the date of registration.
Which is key, I imagine, because I think, is it 30 days you have to register the deposit from receipt of payments? Is that correct?
Yeah, that's absolutely right, Angelos. And if we have to go to court on a Section 21 eviction, some of the documentation that has to be supplied to the court includes copies of the prescribed info and also the protection certificate.
So you mentioned Section 21 there. So I know there's a couple of types. Do you want to go through, just for the listeners, what a Section 21 and a Section 8 notice are?
Those are the ways in which you seek to recover possession of a property let out on an AST in a lawful fashion. I stress lawful because if you don't get it right, then you can be saddled with a claim by the tenant for unlawful eviction and potentially have to pay them something in damages, i.e. monetary compensation. Section 21 is the most commonly used and the most well-known way of getting a tenant out. That involves service of a written notice giving the tenant 2 months to leave. There are various criteria you've got to satisfy with. Section 21. But if you get the notice right, and then if you do have to go to court, you should get your possession order. Section 8 is rather different. The 1988 Housing Act, which created assured shortholds, sets out a number of grounds for possession. Section 8 is the basis by which you can proceed, and the most common ground, you may not be surprised to hear, is rent arrears. That follows a similar format. Service of notice. If the tenant doesn't pay or doesn't go, then you need to make application to the court for the possession order.
Okay, that's brilliant. Thanks, Philip. And I know there's a few others documents.
Yes.
So the AST and the registration deposit and prescribed information, I think a lot of people would know about, but there's some other documentation that's required right up front.
Yes, absolutely. Perhaps the most important, some relatively new stuff. We had a piece of legislation which came in back in 2015 with the delightful name of the Deregulation Act. It is, though, extremely important. It applies to new ASTs granted since the 1st of October 2015, and specifically there are 3 documents that must be supplied to the tenant, primarily, or most importantly, at the outset of a tenancy, or in any event before any Section 21 possession notice is served. The first document is the Government How to Rent Guide. The second is an EPC, the Energy Performance Certificate, and the third is the Gas Safety Certificate. Absolutely essential. I've already had some cases where I've encountered problems because landlords have not provided those to tenants. That's really important. What's also important is any disrepair notices that have been served on the landlord either by the tenant or by the local authority. If we're looking to evict under Section 8, I'll need to see a copy of an up-to-date rent statement so that I can check A, what the rent arrears are, and B, that they're above the threshold for us to proceed on that specific ground. If there is a guarantor, which often there is, I'll need to see a copy of the guarantee agreement. And if we've got an HMO, which is a licensable HMO, I'll also need to see a copy of the licence.
So there's a fair few documents
Yes.
to have fall under. It's not just rock up on the day and give them an AST.
Absolutely.
So Phil, I want to serve notice now, hypothetically, on these people. Do I just rock up to the door and just pass it to them, say there you go, and that's it? I mean, what is the best way to serve this to the tenant?
Well, you can do that, Angelos, that's perfectly acceptable, but the best way, and perhaps the most 20th century way in fact, is by first class post with a covering letter. Written notice, covering letter, enclosing 2 copies of the notice. That's really important. One is for the tenant to retain, and the other is for them to sign and date and return to me if I'm doing the notice.
And so that's interesting. So you said quite 21st century, you know. So how do you prove that they've actually received that?
Well, we take advantage of a principle of law which provides that in the absence of evidence to the contrary, a document served by first class post is deemed served 2 days after posting.
And what about email? What does the court view about email sending of these documents to the tenant? Is that as good as post, or is post, usually recorded first class delivery, the best method of delivery, would you say?
Post would be the standard way, not least because it's very often the first time I make contact with a tenant. There are situations in which the law permits service of documents. Sorry to use a technical term, guys. Service, in the words of a lawyer, means sending something to somebody. So service by email can be acceptable, but generally speaking, the recipient needs to have indicated to you in advance that they will accept service by email.
Okay, that's cool. So basically then, Phil, if ever I need to go down this road, I need to make sure that I cover all bases. So
Yeah.
in person, in post, by email, text message, courier pigeon, smoke signals, any way I can, just to prove that notice has been served. Is that the best way to do it?
Well, you can use some of those,
Yeah.
but post is the best. And just for good measure, as I say, I provide the tenant with 2 copies. I ask them to sign and date and return the second one, and I send them a prepaid envelope for that purpose. It's not very often that they do that and I get it back, but if I do, it's kind of extra proof, if you like. But generally speaking, mere service by first-class post will be sufficient for the purposes of the court.
Yeah.
Because I, as a lawyer, always have to have an eye to the court.
Fantastic. So, kind of all being well, if someone comes to you with one of these issues, and maybe it's different for different circumstances, but how long does it usually take for you to get the landlord's keys back for the property and to have it vacant?
Well, there's 2 parts to my answer to that, Murat. The first is if we get the easiest possible outcome and the most straightforward, and that is a tenant complying with a notice. If we go down the Section 21 route, 2 clear months' notice has to be given. So if they go in response to the notice, happy days, you're looking at roughly 2 months. If it's Section 8, you've got to give 2 clear weeks' notice. But if you've got to go through the whole court process, then it will take longer. In very brief terms, if it's a Section 21 eviction, you could be looking at roughly 4.5 months or so. That's from service of the notice, through making the application to the court, obtaining your possession order, then appointing the bailiff and actually taking possession. It's the same essential process with Section 8, though it does tend to be a little quicker. You're generally looking at roughly 3.5 months or so from start to finish, if finish is eviction via the bailiff, which it often is. I had one such case outside of Plymouth yesterday where we had to go all the distance. The tenant had actually gone yesterday, but their belongings were still there, including some stuff in the fridge.
So what happens in that situation? Does the landlord have an obligation to look after the tenant's possessions for a certain amount of time, or can he chuck them away? What happens there? What's the correct way of disposing or giving back the tenant's property?
Well, there is an obligation. You can't just come along and chuck out anything unless it's obviously rubbish. The generally accepted view in terms of giving a tenant reasonable time to collect, which you have to do, is anything up to 4 weeks. Remember, it's their belongings. You've got your property back, but their belongings belong to them, and you've got to tread very carefully. Again, if you don't get it right, you can potentially land yourself with a problem and even a possible claim.
Interesting, very interesting. So a tenant's not leaving, negotiations or the service of the notice, it's been done, but they're still not moving out. I suppose the bit we really want to get into is on what grounds are you getting the eviction through the court, and have you got examples of some recent cases that you've won and it's been successful?
Well, starting with Section 21. Section 21 is a great bit of kit, in my view, because from a landlord's perspective, if you get it right, it's pretty straightforward to recover possession. If they don't comply with the notice, again, to make the eviction lawful, you need to make an application to the court for a possession order. Generally speaking, the tenant will have little, if any, basis at all in law for defending that claim, provided that the judge who deals with the application is satisfied that all the relevant paperwork is there, that a valid notice has been properly served, and if the tenancy deposit regulations have been complied with.
So what about in the instance where actually the landlord's gone in and hasn't given those notices up front and the right documentation? Is it something that you'll still be able to recover when the eviction point comes, or when you want the property back. So if they've tripped up and they've missed out doing it up front.
I can, but it may take another go, another bite at the cherry. Sometimes I pick up cases where the landlords tried to do it themselves, fallen into some traps, and we've got to start again basically and try to get round it. Invariably there will be a way to do it, but it usually takes a bit longer, and it costs a bit more as well.
So what would you say, Phil, are the common trip-ups? So picture the scene, you're in front of the judge with your client, and obviously he's very upset, he wants to get his property back as soon as possible. What would you say the most common trip-ups are when you are in that position?
Probably the most common, Angelos, is deposit-related issues. Since tenancy deposits came in just over 10 years ago now, I've had a raft of deposit-related cases and issues, otherwise translated as problems. Because if a tenant brings up a tenancy deposit-related issue and there's some substance to it, to quote Apollo 13, Houston, we've got a problem.
Yeah.
Not necessarily an insurmountable problem, but we can have a situation where the court refuses the application and we've got to go back to square one and do it again.
What about, I know you mentioned earlier about the disrepair notices and things like this, and perhaps they haven't served a valid notice. Maybe they've done it themselves and Section 21 hasn't been prescribed properly. How do you overcome those kind of issues?
When you mentioned disrepair, disrepair can kick in both with Section 21 and Section 8. One of the new features that we'll have to contend with as landlords is something called retaliatory eviction. Sometimes in the past it was felt that Section 21s were served on tenants because they've raised disrepair issues. Well, what the government has done now with the Deregulation Act is to bring in a provision which means that if a disrepair issue has been raised, notices have been served, landlord is prevented from taking eviction action under Section 21 by serving a possession notice until they've sorted the matter out. So that's something you've got to be very careful of.
And just picking up on that point, so I guess there's advice to landlords around an audit trail for logging maintenance issues and some kind of way that they can prove that they've addressed everything that has been that's been raised.
Absolutely spot on, and it's absolutely crucial that you do that. I had a case last year. It was a Section 8 rent arrears case, probably here in Plymouth, and I rocked up at the hearing, usual stuff, done it many times before, and the tenant was there. Most of the time they don't turn up, and it's pretty straightforward. The tenant was there, took advice from the duty advisor, and a disrepair issue was raised. I knew nothing about it. I hadn't been told anything about it, either by the landlord or the agent. I had to obtain some pretty swift instructions. I was able to resolve it because I was able to cut a deal with the tenant. That was only because my landlord was prepared to take a sensible view. But essentially, it was trial by ambush, and it could have been avoided because I was actually told by the agent that something had been raised, and I think there was a problem with a hole in the ceiling. Well, you can probably imagine what I thought. If only I'd been told sooner, forewarned is forearmed, and I could have dealt with it differently.
Mo, you raised a good point about auditing and tracking.
Yes.
What's the best way, Phil? Because at the moment I deal with problems with email and sometimes text message, and I keep all the text messages and I keep all the emails for my own purposes. Is that sufficient for a judge to see that you are being proactive, you are fixing these problems in a timely manner?
Yes, it can be. Any written evidence, Angelos, will be helpful. To what extent depends obviously on the given case, but anything and everything that you do that either is relevant or you consider may be relevant, get it recorded in writing. It's about sometimes being preemptive and thinking, what if in the future there is an issue? What have I got that I can cover my back with? What will my lawyer wish to see?
And earlier on, you mentioned that the timelines involved, and it said it can extend to months, and especially it's very costly if you have to go back a couple of times to court, etc. Is there any way that a landlord, so their tenants fall into rent arrears, they've then engaged some services of someone similar to you, and legal fees are built up. There's further rent arrears because the property's still not having any rental income. Is there any way that they can reclaim any of that money?
Well, yes, there is. At the hearing, this is a Section 8, obviously, you're entitled to claim for the ongoing arrears. In other words, you're not limited to the arrears at the level they were in the possession notice. There is an ongoing obligation in the tenancy agreement to pay rent. A tenancy agreement at the end of the day is a legal contract. So you can obtain your CCJ for the arrears outstanding at the date of the hearing.
And what about court costs? Can you include that?
You can claim costs, but unfortunately by law, the judge dealing with it only has power to award a very modest fixed amount. They've got no real discretion beyond that.
So the primary purpose really is to get repossession of the room and clear some of the arrears that might have built up, and you've just got to look at the money that's spent on that process as kind of money invested to get the room back, to get it lettable again.
Yeah, pretty much right. Certainly in terms of costs, so far as the arrears are concerned, there may be steps that you can take subsequently to enforce a CCJ. For instance, listeners will probably have watched the programme on TV, the BBC One programme, The Sheriffs Are Coming. There are similar ones, I think, on Channel 4, Channel 5, if there are assets to seize. Probably the best one is if your tenant is working. If they're working in the local Morrisons or Tesco's, you can apply for something called an attachment of earnings order, whereby you can get money deducted from the salary by the employer of an amount set by the court. That's then paid by the employer to the court, and the payments are passed on to the landlord.
Phil, for our listeners at home who may or may not necessarily be fully aware of how this all works, what top 3 tips do you have for listeners who are considering or just would like to know for the future how to regain possession of their property lawfully?
I think it's very much about risk management. I would say number 1, ensure you get it right at the outset. Comply fully with all the applicable regulations if you're granting a new tenancy. Make sure you know what they are. I still receive instructions from landlords who, when I mention deposits, look at me quizzically as if to say, regulations, well, what are those? Have you registered a deposit? No. Have you provided prescribed information? Well, what's that? And I kind of do my best Edvard Munch, the scream, and then I say, Houston, we've got a problem. Again, it's not insurmountable, but it'll often take longer and it will cost more. For landlords, the 2 main questions for me, how long will it take and how much is it going to cost? You can save yourself a lot of time and money by getting it right at the outset. That's whether you grant a new tenancy or, particularly if you're a portfolio landlord, you're adding to your portfolio, you're buying a property which is already subject to a tenancy or tenancies. Just make sure that it's fully compliant. Your solicitor will help you with that. My second top tip, and it follows on from the first one, is keep copies of all relevant documents. Even stuff you think, it may not necessarily be important, just keep it. That applies equally if you are taking on a property which is subject to an existing tenancy. And the third one, which is the general one, it's look before you leap. Don't go ahead and take any action before you've spoken to your agent, if you've got an agent, and before you obtain proper legal advice. Because if you do it like that, you can avoid the pitfalls and the problems and save yourself time, hassle, and money.
Phil, thank you so much. It's fantastic. So Phil's from GA Solicitors. I'm sure the listeners that we've got will have a few questions for you to follow up with, and will have got a lot of value out of today. What's the best way of them reaching you, getting hold of you?
Well, they can ring me on 01752 203 517, which is my direct line number. If I'm unavailable, my assistant Tricia Eyre can be contacted on 01752 203 525. Alternatively, they can ping me an email. My email address is beginning with lowercase philip.oke at uppercase G, uppercase A, and then in lowercase solicitors.com.
Brilliant. Thank you again, Phil, and thank you to the listeners at home for listening to Pig Pods, Your Success Podcast. Please click subscribe, leave us a review, and we look forward to your comments in the Pig Pod Facebook community. I've been Angelos.
And I've been Mo.
See you again on the next exciting Pig Pod.
You've been listening to Pig Pods. Click subscribe for more incredible content. More details can be found at www.pig.network.